estar nuevamente en una sesión del Seminario de Derecho, Cultura y Sociedad. Esta semana tenemos a dos muy importantes invitados, que son, por un lado, Mariana Pargendler, que es profesora de la Fundación Getúlio Vargas en Sao Paulo, y al profesor Kevin Davis de la Universidad de Nueva York en Estados Unidos. Es un gusto tener la posibilidad de discutir estos temas de interés común que se centran en las intersecciones entre el derecho contractual y la justicia social, viendo particularmente estos objetos de estudio desde la perspectiva de las relaciones entre el norte global y el sur global. Es realmente un placer tener a Mariana y a Kevin hoy con nosotros. Como siempre, en el seminario, la dinámica va a ser la siguiente. En primera instancia, Kevin y Mariana tendrán la posibilidad de presentar los elementos centrales de su texto en alrededor de 20 minutos. Posteriormente, abriremos la posibilidad para que hayan preguntas, comentarios, críticas, de manera que tengamos una discusión tan vibrante como sea posible. Kevin, Mariana, welcome. It's really a pleasure to have you here. It's really a great opportunity for us to discuss your paper on contract law and social justice, and how this is framed within theoretical views that are connected to both comparative law and to issues related to how to understand social justice and the connections between the global north and the global south. As we agreed, the session will be divided in two parts. The first part, you will present the key elements of your paper in around 20-25 minutes, and then we will open the floor for hopefully a vibrant discussion around your paper and around the ideas that you will present today. Again, welcome, and please, Kevin, Mariana, go ahead.
Thank you very much, Daniel. I think for the purposes of presenting the paper, I will use some slides just to try to be as efficient as possible. So as far as the central elements go, here it is. The paper is about contract law and really what we see as a discrepancy between contract law as it exists in at least a few developing countries and the way contract law is imagined to be, right? So the conventional view is that contract law is pretty much the same around the world, that contract doctrine in both developed and developing countries looks like it does in what I teach in New York or what Mariana teaches in Sao Paulo should be fairly similar, and that the real difference is in the quality of enforcement. And so when you see the World Bank reporting on the quality of contract law in different countries around the world, what they actually focus on is differences in the quality of enforcement, which might make sense to an economist, but from a lawyer's perspective, what they're looking at is civil procedure instead of contract law, right? But I think it reflects this view that, well, no, the contract law itself, the doctrine is fairly consistent, right? There's also a perception, particularly amongst academics, and perhaps this is more true in the US than other places, that contract law isn't concerned with economic inequality, right? That the primary purposes of contract law are to promote either efficiency or to give effect to the intentions of the parties, so to respect individual autonomy, or maybe to ensure equality in exchange as between the two parties, but it's not about societal inequality. It's not about differences between groups in society, right? Okay, so that's the conventional view. What we're trying to do here is to suggest that there are instances in which the conventional view is inaccurate, that the contract laws of at least some developing countries are heterodox. They don't conform to the orthodox view. And they're heterodox in the sense that they involve overt attempts to achieve distributional objectives like tackling inequality and protecting disadvantaged groups. And we try to demonstrate that through case studies of contract doctrines in South Africa, Brazil, and Colombia. Now, we're not claiming that contract law heterodoxy is the complete opposite of orthodoxy. Right? It's a continuum, not a dichotomy. And we're not suggesting that these three countries, or any developing countries really, have the same kinds of heterodoxy, right? Or that heterodoxy is dominant in any of these countries, right? It's just that we think that this is some evidence that the conventional view that suggests that there is significant uniformity, and particularly uniformity around the idea of ignoring inequality, well, that view doesn't seem quite right. So one other caveat before I get to the substance of the paper, we don't cover employment and labor law, right? And that's because we think it's well recognized that labor law varies across countries, and that labor and employment law are actually being used to counter inequality. So even though it fits within contract law as we see it, we're not focusing on that. We're focusing on heterodoxy in other areas of the law. Okay, so again, just to be clear about what we think of as the orthodox view. Contract law is concerned with autonomy, efficiency, or equality in exchange, but not distribution. And that is supported by several theoretical arguments, actually, that are reasonably persuasive, that suggest that redistribution through fiscal policy, so through the tax and transfer system, is the most legitimate way of achieving distributional objectives. So that's based on a particular view of the role of courts as opposed to elective legislatures. So that suggests that distribution through the courts is illegitimate. And then it's also based on a sense of institutional competence, that distribution through judicial decisions is likely to be ineffective because the courts don't have very good information about the parties and the effects of their actions. So whatever they do will not be terribly accurate and won't be easy for the parties to predict, whereas the tax authorities have much better information. The courts can't undertake comprehensive forms of redistribution because they can only distributed wealth between the parties to contract litigation, as opposed to the broader set of members of society. There are concerns that distribution through contract law or private law generally is inefficient because it's much easier to give people money than to give them, which we know they want, as opposed to giving them contractual entitlements, which they may not value quite as highly. Right? There are concerns that parties can always avoid the effects of any contract doctrines that are designed to redistribute wealth just by altering the terms of their contracts, other terms of the contracts, like the price, or just not contracting altogether. And then finally, there's a sense that, well, there's a targeting problem, right? What if the parties are interdependent? Right? Like the worker actually has shares in companies through their pension plan. Well, if you try to redistribute wealth from the company to the worker, well, that's actually hurting the worker's pocket as well because of their ownership in the pension plan in this example, right? So there are all these fairly cogent arguments that suggest that redistribution through fiscal policy is more legitimate and more effective than trying to redistribute through the contract system, through contract law. Right? But when we went looking, we found instances in which it seems like courts were still trying to do it. So starting with South Africa. In South Africa, contract law applies horizontally, constitutional law applies horizontally, right? Contract law has to conform to constitutional values, including a distinctively South African value known as Ubuntu. Right? Individual contracts aren't really subject to constitutional scrutiny, but the contract doctrines are. And there are a few cases, at least, where we found that the Constitutional Court has taken this view very seriously and has suggested that contract doctrines of various sorts have to be modified to respond to the significant inequality that is still present in South Africa. So this is a quote from a case on whether or not to limit the accrual of prejudgment interest after litigation has started. So whether the interest would continue to run while the claim was being disputed, or whether there'd be a pause, right? And the court suggested, no, we should pause, we should suspend the accrual of interest, which seems to, at least at first glance, benefit the debtor. And part of their reasoning was because in the typical case, although not in the case they were deciding, in the typical case, debtors in South Africa were likely to be relatively poor. They were likely to be on the wrong side of the vast economic disparities in the country. And they traced that back to the legacy of racism and apartheid, right? And it's so, we think this language that we quoted here clearly suggests that the courts are sensitive to inequality, and that's influencing their decisions about the contours of contract doctrine, at least one particular contract doctrine. But there are limits, right, in South Africa. There was another very famous case where the court was asked to override contractual language that disadvantaged some franchisees who happened to be Black and were beneficiaries of a program designed to empower Black entrepreneurs. And the court said, no, we're not going to do it. Overriding a very interesting trial decision, we're not going to interpret this contract differently simply for the sake of trying to protect disadvantaged people, because actually we think that could hurt more than it would help, right? It would discourage people from contracting with poor Black entrepreneurs in the future. So there is some contestation around these initiatives. It's not like we're suggesting that in South Africa, heterodoxy prevails everywhere and that every decision is motivated by the desire to redress historical disadvantage. And the same, I think, would be true of what we find in Brazil. I won't go through the cases in any detail because there's limited time here. But in Brazil, we describe a series of cases where the courts have made it significantly easier than the orthodox view would suggest it should be for people who've agreed to purchase housing, prepaid for begun to purchase housing, and then default, right? And the question is, can they get back the payments they've made? And the courts have said yes, subject to only initially a relatively modest, I'll call it a penalty. If they could get back all but 10 or 15% of what they paid, which is not necessarily the result you'd expect under Orthodox doctrine, where they'd also be liable for damages. But that seemed to be, again, designed to protect the purchasers of the housing, in part because of the societal consequences of failing to do it, right? And so we trace those cases. We also talk about some rules around penalty clauses insisting they have to be symmetrical, some insurance contract cases, all of which seem to be very pro-consumer, pro-beneficiary, and motivated to some extent by the social concerns about the social function of contract law. And that rhetoric is certainly very present in the decisions and is probably familiar to you from the Colombian context as well. But again, in Brazil, it's not a one-sided story. There's actually been a backlash against some of these judicial initiatives. It's reflected in particular in a law on economic freedom that was passed in 2019 that suggested that no, contracts should be interpreted in favor of economic freedom and respecting freedom of contract, and that judicial revision has to be minimal and exceptional. Right? So it's not clear that this was terribly effective, but it was part of a pushback against these moves towards incorporating social considerations into contract doctrine. And then in Colombia, I suspect many, if not all of you, are more familiar with this than I am and have far more expertise. But we were struck by some of the constitutional court's decisions that were designed to protect some of the subjects of special constitutional protection, basically disadvantaged, who we identify as disadvantaged groups in contracts cases, not only in the insurance cases, health insurance and life insurance, but even in the case on the right to terminate the provision of water, where the court restricted the ability to terminate the water supply contract, in part, as we understand it, because the household in question was relatively disadvantaged. And that seemed, again, to be based not just on their relative bargaining power, or that the agreement was unfair in some way, but because of their social position. Right? So those are the kinds of cases that we're talking about, which we think of as being very different from the orthodox view and different from what you see in say, the United States, right? Where you can find a few examples, a few very famous examples of courts trying to give effect to the law of the poor. But actually, when you look for judicial decisions like this, you come up with maybe two, and they're by the same judge. They're very famous, so I teach at least one of them, the Williams versus Walker Thomas case, right? Which had the effect of protecting a woman on public assistance, a Black woman on public assistance, from enforcement of a truly unconscionable security agreement, a clause in a credit agreement, right? And then there's another case by the same judge that was about the implied warranty of habitability, saying that the housing had to meet certain minimal standards, right? And the judge, Judge Skelly Wright, made it very clear in the second case, and then in his extrajudicial writings, that part of what he was trying to do was to provide a remedy for racial injustice. But these are the only cases, right? You can't really find many more examples of this in the United States. And the doctrine has evolved, certainly evolved in a way that rejects the view that these are appropriate concerns for judges in contracts cases. Europe is a little more complicated, right? There certainly is more concern with consumer protection in continental European law, right? But we think of it as still being fairly orthodox in the sense that the concerns are often about the equality between the parties, right? As opposed to broader societal disadvantage. That's our interpretation of some of the more famous cases from Germany and Italy and France. And so we don't see quite the same tenor, quite the same tone in the European cases that we see in the cases from especially South Africa and Colombia. Now, on the academic side, there's certainly support for taking into account considerations of social justice. And certainly there's more support for that in the European scholarship than you'd find in the American scholarship. But we don't actually see it in the case law so much. And I'll skip this just in the interest of time, but we're interested in some of the more recent emergency legislation, whether this marking a shift towards taking into account broader societal concerns, but perhaps we can talk about that in the question and answer period. I'll just close by suggesting, by putting forward our theory as to why we see these heterodox approaches in some developing countries, and these developing countries in particular. And we think there are three factors that might explain it, perhaps in combination. One is that these are countries where inequality is highly salient. It's a major social problem, right? And it's salient in that it's linked, in part because it's linked to historical injustice and with racial overtones in all three of the countries that we discuss. So that's part of it. And then secondly, the fiscal system has failed to tackle it effectively, right? And perhaps not surprisingly, and perhaps as a consequence of those first 2 points, the courts there seems to be more acceptance of the idea that it's legitimate for courts to use contract law to try to respond. So these are three countries in which the idea of transformative constitutionalism is well accepted, right? That courts can act, it is legitimate for courts to use the law, including private law, to try to change society contrary to the orthodox view. And we see that being reflected in contract law. So we think it's that combination of factors that explain these outcomes. So there are certainly limits, as I've suggested in each of the cases each of the countries that we discuss. There's been contestation of heterodoxy, and even the examples we show, well, it's not clear that, I think more research needs to be done to figure out whether they're functional equivalents in some countries, like whether bankruptcy law in the US, for instance, serves the same sort of purpose, serves as a sort of social safety net that makes up for the absence of that kind of safety net in contract doctrine. And it's quite clear that some of the concerns about the lack of effectiveness of, or the reasons why contract law might not be an effective way of achieving distributional goals still apply, right? It's still the case that these courts are not going to be able to, that contract doctrine isn't going to affect the lives of everyone. It's primarily going to affect the middle class, people who can afford to litigate, right? And there's the ongoing concern about people essentially contracting around these doctrines, avoiding them by either not entering into contracts or changing the price terms to negate the effects of the doctrine. So we're not claiming here that heterodoxy has necessarily been successful. The point is simply to suggest that it exists and should be taken seriously. Of course, if we wanted to be more ambitious, we could suggest that maybe it will spread and we might actually see more of it in the developed world. That could be the trend, given the rising concern about inequality in developed countries, and also changes in the academic literature, where there seems to be more openness to this, to the idea. But for now, we'll leave it with saying that this is phenomenon that we've observed that seems to contradict the conventional view, or at least call into question the conventional view. We think that this is important for a few reasons. First of all, for comparative lawyers, actually, or for, well, scholars, legal scholars generally, I think it highlights the value of comparative law, and comparative law that looks beyond the usual suspects, that goes beyond just comparing England and France and Germany and the US, and looks at the developing world and a range of countries in the developing world. Right? It has practical value. Obviously, it's good for practitioners to know, I think, that contract law isn't necessarily the same wherever you go, to be aware of that fact. Obviously, it has significance for contract theory. And I think this analysis also at least opens up an interesting research agenda for scholars of law and development and law and economics who might be interested in analyzing the effectiveness or the impact of heterodoxy, which is, again, not something that we've tried to do here. But I think that's basically it. I'll stop there, and I look forward to your comments and questions.
Thank you very much, Kevin. It was very interesting. So we'll now start with comments or questions by the audience. I will say it also in Spanish, and we can get started. Estaba diciendo que llega el momento de los comentarios o preguntas por parte de la audiencia. La idea es que hagamos comentarios o preguntas breves de manera tal que podamos participar el mayor número de personas. Voy a moderar esta parte. Entonces, por favor, les agradezco que alcen la mano si quieren hacer sus preguntas, o también que las escriban en el chat y nosotros se las comunicamos a Mariana y a Kevin. Están invitados a hacerlo en inglés, o si prefieren lo pueden hacer en español, bien sea vía chat o verbalmente, y Daniel y yo haremos nuestro mejor esfuerzo por traducir las preguntas o comentarios. Entonces, no sé quién quisiera empezar. Daniel y Mariana. Voy a darle prioridad a Mariana, que es nuestra invitada especial, y después puede ser Daniel. Entonces, Mariana, y Sergio, que también es profesor de la facultad. Entonces, Mariana, Sergio y Daniel, si les parece.
Well, thank you very much, Kevin and Mariana, for sharing this wonderful paper. As I told you before, it has been a very great interest for me, the idea of social justice in private law. And I'll try to be as organized as possible because it interests me so much, and I have so many comments and interests, but I'll try to focus on a few of them. First of all, there's something that I thought about when scholars like you guys talk about the social justice in contracts as maybe a tool of to distribution, or that it has distribute objectives. But I've been wondering for a while about that, because I'm not sure the fact that we understand that we need contracts to be fair, and like a fair game in contracts should mean that we are distributing wealth. Excuse me. I will try to explain myself. If it's a matter of distribution of wealth, that you want to take the wealth of someone and give it to someone that's poor or not, and that's something that I'm not sure that should be like the main goal of the social justice in contracts. Because I think, and as maybe René Demog in France explained it, a contract has an effect of the society, of the whole society. So we want contracts to be fair for all parties, not only the weaker party, but also to the other party. You have in the paper a very interesting decision. I don't remember if it was in Italy, that it was a judicial decision that helped. I think they were like sorties, that they were not the weak part of the contract. I think it was an Italian decision, and that's good. And in insurance law, of course, the weaker party can be the client, but the client needs to behave in good faith also, and it has to cooperate also. And maybe it's a matter of avoiding the abuse of right. Of course, in inequality societies, that can happen with the party that has more control over the contract. But my question for you is that, is it really a matter of distribution, or is just to be more civil as a society, and it can affect not only the weak parties in the contract, but also the any party, big enterprise as well. That's my first question. Sorry, I'll try to be more to shorten my intervention. My second question is, in that sense, is consumer law considered a distributive tool? Because a consumer law aims to protect the weaker party, the consumer. But I have not seen that consumer law as generally thought of as a tool for distribution. Not exact. At least it's not what I have seen. I wanted to know if you see it that way too. And the last question for you is that if you think all this great analysis that you do in this article relates to this doctrine of social force majeure. I don't know if you've considered that doctrine of social force majeure, that it's been developed by Nordic countries, and it considers the context of the parties, even in a very in a wealthy developed countries as North European countries. Those are my questions. Sorry if I took a little more time. Thanks.
No, thank
Mariana.
you. Yeah.
Go ahead, Kevin, please.
Thank you. So I should say, first of all, that the other Mariana Pargentler, my co-author, is here. So we agreed that I would do the presentation, the initial presentation, just to make sure that we were reasonably concise, but she will also be jumping in to answer questions. So I'll lead off, but then I'll open it up to Mariana Pargendler to respond as well. On the first two questions, we do try to draw a distinction between concerns about fairness on the one hand and concerns about distribution on the other hand. And actually, because in some of the literature, fairness can be applied either at the societal level or at the inter-party level, we don't use the term fairness, actually. We talk about equality, we try to distinguish equality in exchange, concerns about equality in exchange, from concerns about distribution, right? And so I think the simple answer to your first question is, yeah, we think those are distinct. We think that the orthodox approach is concerned about equality in exchange and fairness and good faith and just as between the two parties, did they both have a fair shot at benefiting from this transaction? Was the transaction at the time they entered into it likely to be equally beneficial? Did one abuse their bargaining power in some way? Those are concerns about equality in exchange and inter-party fairness and so forth. That has nothing to do with more systemic concerns necessarily, because it could be the case that the stronger party, in a sense, is also more disadvantaged, belongs to the disadvantaged group. They're stronger in that particular transaction, but they're actually members of a disadvantaged group. And so the distinction would really bite there, right? And we're suggesting the heterodox approach would be to try to shape doctrines to help the disadvantaged party, regardless of whether they behave badly, well, perhaps regardless of whether they behave badly, and perhaps regardless of whether they're weaker or whether there's an imbalance in the exchange, right? So we do think there's a distinction. But obviously, in many situations, there'll be overlap between doctrines that are designed to ensure equality in exchange and doctrines that are designed to protect disadvantaged parties, because often disadvantaged parties, members of socially disadvantaged groups, are also relatively weak in relation to the counterparty of the contract. And so that's why many aspects of consumer law can be justified on either ground, right? You can say consumer law is about protecting parties who are at a disadvantage relative to their counterparty, relative to the seller, because they have less information and they have relatively few choices, right? They have less, they don't have market power. Or you can say that the consumers in some societies are relatively poor people, and it's consumers of certain types of goods could be relatively poor, and we want to protect them for that reason. And there it's impossible to distinguish. So that's why but in principle, we think there is a distinction between the two types of objectives. So that's what I wanted to say there. And then I actually am not familiar with the social force majeure doctrine, which is part of the beauty of these presentations, right? We didn't go that far north, as it were, in our comparative analysis. But it's certainly something I will look into it. I can only speak for myself, though. Mariana?
No, I mean, I had not heard of the social force majeure doctrine either. And I must say, we presented this paper not in the Nordic countries, but in Northern Europe, and no one pointed us to it. So I think that's very interesting in terms of a contrast, because of course it's in terms of having a welfare state, it's you know, the Nordic countries certainly have it, and it is interesting. It will be interesting to see to what extent they still incorporate concerns about social justice into certain contract law doctrine. So I was just as I said, I started like Googling immediately, and I think that's going to be very, very interesting for us. So thank you for that. We were actually not aware about the doctrine, which is why it's so amazing to present this paper for such a wonderful audience.
Thank you. Thank you so much.
Thank you, Mariana and Mariana. Now, Sergio. Your microphone is off, Sergio. María Paula, ¿será que tenemos cerrados los micrófonos? ¿Nos puedes ayudar con eso o habilitar micrófonos? Sergio, me dicen que ya puede, si activa su micrófono. Eso.
Okay, thank you, Manuel. Firstly, I want to acknowledge for a refreshing paper that certainly challenges my conception of contract law. And thank you for that for first instance. And saying that, I just want to make a little comment, actually. As you pointed out, in your paper, legal heterodoxy has usually focused on certain areas. For example, consumer finance, consumer law in general, healthcare, and the provision of public services. But I wonder whether it's plausible to extend this approach as a general approach. And certainly I'm skeptical. Let me make a little comparison to TELA claims related to healthcare, because intuitively, tutela in Colombia, at least in Colombia, seems a proper mechanism for protecting fundamental rights, but zooming in, it turns quite costly, considering, for example, adjudication and judicial infrastructure cost. And certainly this problem matters in Colombia, considering that in 2019, judges settled over 200,000 claims related to healthcare. So if we adopt this kind of approach in contract law, it could be certainly difficult and could, at the end of the day, could delay the ordinary cases, for saying in some way. In this sense, I think probably that this approach should be exceptional and temporary, and we should prefer legislative intervention, as it happened, for example, in consumer law, that Congress developed a singular regime that protect the weaker party, as Mariana says. In the same way, we have a singular law or regime related to the provision of public services. No, so my question is, at the end of the day, is it's plausible to extend this approach as a general approach?
It's possible, and whether or not it's that has happened in Colombia, I think in the case of South Africa, at least, you see decisions that do not involve consumers. So the Paulson decision that we described, and even the Botha decision, those both involve business people. The Paulson one actually involved very substantial sums of money and significant business transactions. So in principle, it's possible to apply the approach beyond the consumer context and beyond the context of individuals more generally. Although if you don't have an individual party, the concerns about targeting become much greater, but it doesn't have to be limited to consumer cases. But your other question is about the not about whether it's possible, but whether it's a good idea, whether it's likely to be effective to do this. And in a context with limited judicial capacity, then I think it's a perfectly fair question to ask that. And which is why we think that that's the next step in the agenda, to actually study that, right? Because I could say, well, it doesn't have to turn out that way. You don't necessarily have to it doesn't necessarily have to lead to excessive litigation if most of the cases settle, if the doctrines are developed in a very clear way, at least in the American context. We'd expect most of the cases to settle out of court, so it wouldn't necessarily overload the courts and da 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 da. But that's an empirical question, right? And the answer could vary from one context to another, as could the question of whether the legislature would do a better job, whether legislation would be more clear and therefore lead to less litigation, right? There's also the political economy question of whether legislation is likely to be enacted, right? So in some jurisdictions, including the US, in at least parts of the US, the courts can be expected to be more progressive than the legislature, right? And maybe in Brazil now, that would be true as well. So if you are sympathetic to the objectives of heterodoxy, to the distributional objectives, you're just being strategic about these choices, you'd have to ask both, well, first, will the legislature act? And if it does act, will they act in a way that is more effective than the courts? Both empirical questions.
Daniel, I just had a question for clarification. I didn't quite hear when you said 200,000. Was that the general cases before the court in general? Were that what does that number refer to?
Yes.
In your introduction?
Is referring for tutela claims related to healthcare, right? Yes, related to healthcare only, because in Colombia, in the same period, was around 700,000 at least in general.
In 700,000 in general, and so there's a whole lot of healthcare litigation based on tutela, but not all of it is related to contract, obviously.
No.
It's against the state. Regular. Brazil also has a significant caseload, and it's likewise under significant debate. Thank you. That's very helpful.
Okay, now Daniel.
Thank you, Manuel. So first, I would like to say that I enjoyed reading the paper very much. I learned a lot. It was an extraordinary paper, Mariana and Kevin. So I have a set of comments and questions. The first one is about the case selection criteria that you used. Because on the one hand, I wonder what were the criteria that you used to choose the countries that you analyzed, both in the Global North and in the Global South. Because on the one hand, when you read about the Global North countries that you explore, you find the usual suspects, right? You find Germany, France, Italy. And I wondered what happens with peripheral European countries like Spain, Portugal, or Greece, that given their systemic economic problems and also the problems with poverty and inequality, if they might be less orthodox than France, Germany, or Italy. Also, when you read about the Global South countries that you analyzed, you find that, as you mentioned in the paper, these are prominent Global South countries from a legal perspective, right? But I wonder, on the one hand, if these three countries, Brazil, South Africa, and Colombia, are not becoming the usual suspects of the South, right? And also, if the criterion prominent is enough to support your choosing of these countries for representing legal orthodoxy, heterodoxy in contract law. The second common question has two components. The first component is about the role of the case law that you want to analyze. So are these cases examples to illustrate national patterns? Or are these examples to illustrate regional patterns? Or are these examples to illustrate a strong epistemological argument? Or examples to illustrate a political argument? Or all of the above? And perhaps it would be useful to clarify and elaborate on the links among these roles that it seems the case law that you analyze play in your line of argumentation. And the second part of this second common question is about the tension that I would say all comparativists face between analyzing isolated but paradigmatic opinions and lines of opinions or jurisprudential lines, right? Because connected to the first part of this second comment, I wondered if the isolated opinions that you analyze generally are enough to support your thesis about heterodoxy in contract law in the global south, and also about orthodoxy in the global north, because you mainly focus on Supreme Courts. But I wonder, well, what about the rest of courts, or the majority of courts in a country like Colombia, or well, in any country, right? Also because there are differences in the number of cases decided by Supreme Courts in the global north and in the global south. So if you analyze a few cases issued by the US Supreme Court, you will analyze an important part of the jurisprudence of this court on a specific issue. While in the global south, in cases like Colombia, you will find that the Colombian Constitutional Court has issued a very important number of cases on a specific matter, right? So if you analyze one or two, perhaps you're going to lose nuances, you're going to lose changes, you're going to lose contradictions, right? And also you're going to lose, I would say, the tensions between the jurisprudence of these Supreme Courts or constitutional courts and lower courts, right? So perhaps in cases like Colombia, you find the Supreme Court, the Constitutional Court is progressive, and the lower courts are more conservative. In other parts of the global south, you'll find that the Supreme Court is the one that is conservative, and the lower courts are progressive, right? And perhaps, again, these nuances can be lost when you focus on isolated opinions by apex courts. And again, this is connected to, well, what is the role, what is the traction that you want to give to these examples that you choose for your main arguments, regional patterns, epistemological arguments, political arguments. The third comment is related to the connections and tensions between orthodox contract law perspectives and heterodox contract law perspectives in the global south, right? You very clearly say in the paper, and also Kevin said it in his presentation, that you don't argue that this is a dominant view in the global south, right? And in the cases that you examine. But as a reader, I wonder, well, if it's not dominant, and you also recognize that the orthodox view is still very much there, what is the place that you want to give to these heterodox perspectives? Because you might say, well, these are the exception, like in the global north, right? Orthodoxy is still the dominant perspective, and you find in these progressive Supreme Courts some heterodox views that are just starting to push back a little bit the orthodox views, right? Or perhaps there is a more complex relationship between these perspectives. And I think that it would be useful to say a little bit more about this. And the last question is about the political aim of the paper. I think that you say something a bit about this a little bit, but it might be useful to elaborate. And certainly I would like to know more about what are the political aims that you try to pursue with the paper.
Okay, I'll take a stab at that, but this is, I think it'll be interesting. I'll be interested in hearing Mariana's responses to some of these as well. In response to your first question about the case selection, I think it's a great suggestion to look at peripheral European countries. We did not do that. And I think that's, yeah, so we'll take that on board and try to pursue that, because we're actually thinking about how to expand on this project beyond this paper. As far as the selection of countries in the Global South, we didn't say this in the paper because we weren't as systematic about it as we probably should have been. But these aren't the only countries we looked at. We actually did look around for the countries that we were familiar with, basically. So it was a convenience sample in that sense. But we didn't find examples of heterodoxy in the other places, the other countries we looked. So we didn't simply settle on the most prominent jurisdictions in the Global South. So, you know, we have the benefit of having a large number of students from different countries around the world at NYU as LLMs. And so, you know, ask people about Central America and other parts, you know, Anglophone Africa at least. Mariana had students looking in Latin America, in other Latin American countries besides Brazil and Colombia. And these were the best examples, perhaps not the only ones. There's some countries where we just didn't follow up, but we weren't limited to the most prominent examples. Also, I'll say that your perspective, that from your perspective, these may be the prominent examples. And I think that's certainly true for people who focus on the literature on comparative constitutional law. So South Africa, Brazil, Colombia, those constitutional courts, those are those are major players, right? That is not the perspective of people in the private law world. These are, I don't think anyone who thinks about comparative contract law, for instance, if you'd ask them, what are the most prominent jurisdictions for comparative contract law? I don't think that Brazil and South Africa and Colombia would figure, with all due respect. Yeah, even if you limited it to the Global South. So that's on the case selection point. There's an overarching answer to your second and third questions, and maybe even the fourth, which is that the purpose here in selecting the opinions was to essentially to falsify a universality claim, the claim that contract law is always the same, right? Everywhere, and that it never takes into account distributional concerns. To the extent that that's your goal, you have a lot of latitude with case selection. When you're trying to the extent you're trying to test that kind of hypothesis, any counterexample will serve to falsify it. So we felt we had a bit of latitude in that respect. So I think that's the broadest response to your questions about whether the cases were designed to be representative. Certainly not. Either they're not intended to be represented nationally or regionally. I'd certainly take your point about the role of isolated opinions especially in jurisdictions where you've got mass adjudication, right, by the apex courts. So there, there's a chance we're just picking up noise. But leaving that aside, we have some latitude if the goal, again, is just to find some instances that are inconsistent with the orthodox view that this never happens. So for this paper, that was the objective, because it's our first step, right? And I think that relates to the political objective. The objective was not to make the case for heterodoxy, right? It's more, I think the main political objective is really this, is in the realm of intellectual politics almost, what I characterized as the methodological claim in the presentation, which is to say, hey, you should look. The South is a source of so interesting legal ideas, which again is not a conventional view on the private law side. And I think if there's a political objective, that was it. So I think I'll stop there and let Mariana jump in.
I think Kevin covered a lot of ground. I mean, one of the things Daniel was pointing to is everything that we lose by doing what we do, and I think clearly comparative law makes you lose a lot of things because you have to pick certain things to compare. So I mean, I think that's absolutely right. And so in Brazil, for instance, focus on the Superior Court of Justice understates heterodoxy. So I would have a lot more that gets reversed in that court. Maybe the opposite happens in other countries. And I think that now hearing you say it, for me, that was a reason not to use it because it's ultimately reversed. But of course, that's very much part of the lived reality in the country, that you have some decisions for quite a while until it gets reversed. And I think there's a lot of, it's very interesting. There's a lot of regional variation, which is really interesting. Sometimes it's related to industry interests. Some courts in a state of soy planters that are very favorable to the interests of the planters as opposed to the interests of contracting parties. But then there are lots of heterodox decisions and those things. And something that I wanted to say is that I don't know if it's the same in Colombia, but in Brazil, this issue of contract law heterodoxy is a central issue of public debate in private law. There are those major camps, and people think that it matters, that maybe it hampers economic development. Other people think it's a wonderful thing. But those are very central issues in Brazil, as well as other quirks that Brazilian law has in various different areas. Corporate law, another area I work on, and I see some different issues. But they all interpret it internally as Brazilian law exceptionalism. It was this author that said this thing, or this justice and this court and this clause in the Brazilian constitution, without some perspective that maybe we are not alone. And I think that's kind of the terms of an inspiring thread for this paper, is that there are things that are going on in the global South, and these jurisdictions are not alone. It doesn't make it the same way, it's the same mechanism, it's the same effect. But there's something interesting there, which has not, they haven't shared. So I'm not claiming at all. I mean, I found out about Colombia and South Africa, I mean, well into this project, but maybe there's something to be said about general circumstances in these countries, including progressive constitutions and concerns about inequality, that it ends up putting some pressure in private law. And of course, there are lots of questions to be, there's a lot to be said, how much, when, how, but really, this is the first exploratory project, and now we're building kind of narrower projects to test more specific things. And I love also the suggestion about Portugal. I mean, my hypothesis is that they're not the same as France and Germany, and I think I have some anecdotes to that effect. And in terms of also of rhetoric in academia concerning that, so I have this precise sense, and we're not really committed so much to the dichotomy, global South versus global North, but rather having a better sense about what goes on in the ground, and not only in a very abstract way on the books. So I think that that's kind of the primary. Many of the questions were like, is it good? Is it good? I mean, that's not really our goal here, although we try to be sympathetic, you know. So I think where we are coming from, the literature we are coming from, we're trying to say, well, maybe, you know, this is not necessarily awful. So I think that's kind of, you know, it might be a possibility. It might be interesting. Let's look. So, but we're not necessarily defending it. I think there might be many problems for sure. But yeah, so I think so for sure. I think we gain something in this comparative exercise, and we lose other details that we would be able to get for sure. And our hope here, and it's so great to listen to you, because this is kind of our. I think this is kind of in the beginning of our agenda in thinking about those issues, and not our final paper. So I think there are lots of things that we can use from this conversation also to refine and maybe also have, in some ways, I mean, broader coverage of countries and sometimes thicker description in countries, which and those are in tension with one another. Yeah, but I think that's that. But I think the fact that Colombia and South Africa, and to a lesser extent Brazil, I heard that I think yesterday, that it's orthodoxy now. Can you believe it? I said, well, but you're talking about Colombia and stuff. That's in constitutional law. It's orthodoxy now. I'm like, oh my gosh, but that is amazing, and that's important. And in private law, it's not there yet. So let's should we look at it and see if there's anything to be said and for it to be considered, or is the premise of universality just it, and just flawed adaptations and lack of enforcement, or are there interesting things going on? So this is kind of the spirit of our paper, and yes, we rely on the usual suspects. I think for next project we want to rely on global South, kind of where we think we won't find anything. And that's something we're very much interested in, because I think there's a lot of diversity in the global North and in the global South. And maybe there are more categories that we can think about that would enrich the conversation. This is where we are going, and really, this is, it is what it is. I mean, we're still trying to improve it, but I think there's only so much also we could do. But I would love to know if there is a sense about Colombia contract law. If there is a thing, I don't know if it's a thing. I mean, I tried to just find just the decisions we found. We also cannot prove that those are the only. So this is very important. We look at other jurisdictions, but I cannot. So for instance, Argentina. I mean, my sense from my teaching there is that there's a lot of heterodoxy, but I couldn't find the cases. But I cannot disprove that Argentina. I cannot prove that Argentina is orthodox or heterodox. It's just that the Colombia cases seem to be more apt, and then we went with those. But I don't know if that's something part of the legal discourse in Colombia. In Brazil, it is very much the case. You have the camps. It's an established thing, the whole social justice and private law thing. And there are people who are highly critical of it and people who are sympathetic to it. But there is something going on. So even if it's, if it's not all of the phenomenon.
Manuel.
Thank you, Mariana. We have a question from Professor Mauricio Rengifo, who is also a professor from our faculty in private law. I did my best effort to translate it, so here it goes. I hope it makes sense. First, he congratulates you for your paper, which he finds very interesting, but he asks this question. It doesn't seem ideal to use contract law to distribute wealth on a large scale, at least not at the levels that economists deem relevant. One way of doing this would be through pricing regulation contracts, but hasn't this option proved to produce negative effects on the economy? How could we use contract law to distribute wealth in macroeconomic meaningful terms?
Mariana, do you want to take that? What I was going to say is the fact that what strikes me listening to Mariana is the fact that people are fighting about this in Brazil, and that economists are fighting about it in Brazil, suggests that this is significant from a macroeconomic perspective. But perhaps, Mariana, I don't know if you want to add to that.
I think there are different levels to the question. There are different dimensions of the question. One concerns price controls and whatever merits of price controls. And for us, I mean, I think we pondered a little bit, Kevin. One of the difficult things also about contract law in particular is that the boundaries of the field are not crystal clear. I mean, price controls, contract law, we try not to deal with price controls, because if we take that position as being contract law, a good part of the regulatory state will be contract law, and then it's just too expansive. So we try to look at adaptations to contract law doctrines beyond price control, but certainly there's something to be said. Of course, price controls interfere with contract in some highly direct way. I think there are lots of things to be said about price controls, including various bad things to be said, evidently, about price controls. There's also, I think, the second level of the question about, well, can you really tackle inequality on a broad scale using contract law? I think that's a very good objection. I mean, again, we are not launching a defense of heterodoxy, but if I were to defend heterodoxy here, I mean, it was like, well, but that's too broad a goal. The question is not whether it can solve everything by itself, but can it help a hand? Can it help a little bit? Especially because some contracts might end up not only keeping things constant, which is already an unhappy state, but actually making the poor worse off, and really systematically, because for various reasons. So shouldn't we take that into account and not allow risk to be shifted to poor parties, which is what we would get if we let the market operate without some constraints from various sources, including contract law. So, I mean, I think the whole theme about distributing through something that is just going to react to that, because I think we were very careful in the paper. We went back and forth, but then we really try to avoid redistributing, and we just say distributing, because of course whatever allocation we have of wealth is a result of the contract doctrines that we have, and should they be sensitive to distribution considerations? Shouldn't be somewhat sensitive. So I think if there's going to be a defense of contract law heterodoxy, which is not the precise focus of this paper, I think it will probably just we'll have to moderate the hopes and just add, can it help? I mean, given that the tax and transfer system is not doing all it could it help a hand, given that so much of the actual distribution of wealth is also shaped by the contract doctrines that we have? And I think this is a bit of the conversation we would like to inspire. I have to say, and maybe that's why Kevin prompted me to respond to this, is that I've been playing a lot about the idea of the decline in modularity in law and economics. So I call this term modularity to say that traditional law and economics tends to think that each area of law has a single efficiency objective, and distribution considerations should be tackled by the tax and transfer system. And I think really that assumption, which is so central to law and economic scholarship traditionally, is really in a period of crisis. And we see it, I think, very clearly in antitrust law. We see it in corporate law, and I think we sooner or later we'll see it in contract law as well. So, and with that, I'll say that I think whatever force the orthodoxy had, I think currently we're a little bit in a crisis of orthodoxy. There's a lot of discontent about the status quo. Maybe it's reverse convergence, you know. So the developed countries really feel helpless. There are great problems, climate change, inequality, and we should do however we can. And that might lead us to more heterodox solutions, and maybe, you know, some reverse convergence, which I think are the kind of the broader, more fluid ideas that we were discussing toward the end of the paper that Kevin mentioned.
Can I just say something about in concrete terms? Because some of these doctrines affect major markets, right? So like the doctrines that govern prejudgment interest, that's all credit markets. Or some of the cases we're talking about are governing all housing contracts, all residential real estate contracts. Those are major markets. And, you know, sometimes it's even economic theory suggests it's not always possible for the party disadvantaged by the doctrine to contract around them by altering the terms, right? So there's interesting work about basically the incidence of these kinds of contractual measures. So in principle, these could have major impacts. So that's in principle. And then just I wanted to put in a plug for some work by a friend of mine at Yale, Zachary Liskow. He's one of those people who Mariana was referring to, who's suggesting that, well, there's another way, that we should think about many different ways of achieving risk redistribution, that it's actually efficient. He's an economist, actually, and a tax lawyer, a tax economist. And still he's saying, well, actually, we shouldn't be thinking about using the tax system as a sole means for redistribution. We should instead be thinking about 1,000 points of equity. That's his phrase. And so there is an economic case arguing that, well, there are good reasons to believe it could be effective because of the scale of the markets that are affected. And there are reasons to believe it might actually be efficient and as well as effective. And yeah, so I'll stop there.
Thank you, Kevin and Mariana. It seems there are no more comments or questions so far. So I have one. Since this is an ongoing project, as you were telling us, I have a question comment about whether you're interested in assessing the empirical impact of court decisions or legislation regarding contract law and distribution. Because I think that would be a very interesting point to make, to say, because we're discussing, well, okay, this heterodoxy is really useful. It's not a way of measuring it is seeing, well, its real impact on certain societies. So I think that would be very interesting to look at. I don't know if you're interested in looking at the empirical aspect of this question, or you think you're more focused on a theoretical framework. And I'll also ask this, and this is my comment, because I think that this could also help to choose, if you want to choose some case stories which are very representative of whether you want to cover more ground with lots of cases or covering different countries. And as I was reading your paper, you were talking about Brazil and South Africa. You were talking about housing contracts, or the problem of housing for the population. And I was thinking, because Colombia is the last case, I was thinking, well, maybe they're going to talk about the housing problem in Colombia, because we had a very representative case that I think would be very useful to you. Of course, I'm Colombian, I'm saying that it's very useful, but I think it is. And we had, at the end of the 90s, a huge mortgage debtors crisis that was leaving thousands of people without homes. And the Constitutional Court intervened. And it was I think it was a structural decision case, because it affected thousands of people. And it also forced, in a sense, the Congress to make a new law to completely change the way that the Colombian state was with mortgage contract, establishing the rates of interest of mortgages. And I think this is a very interesting case. It was extremely debated in Colombia, because, again, it was a discussion that the Constitutional Court could not make these kind of decisions, which are public policy decisions. But it had a huge impact on the housing market in Colombia, and it completely changed the way that we establish mortgage interests in Colombia. So I think that's a very interesting case because it affected thousands of people in Colombia. It created a huge public debate, and it changed the law in Colombia. So but a question that one could ask as well, was this really meaningful? Did it have an impact on mortgages in Colombia, on savings, on the access to housing in Colombia? Or these kind of very heterodox decisions really create lots of political debate, but they do not have a real impact on very unequal societies like Colombia. So to conclude my comment is, how interested are you in the empirical aspect of this debate and assessing the real impact of these kinds of decisions or legislations regarding contract law?
I'll speak for myself first. I'm very interested, but I've got a bit of a problem, which is that some of my other work focuses on sort of the methodology of empirical research on law. And so I have to be very careful about doing any empirical work of my own, because there's a risk of being hoisted by my own petard, so to speak, being subjected to the same criticisms that I level at other people's work. And to do the kind of work that you're describing, we would then definitely have to confront all of the issues that Daniel raised to make sure that the cases, that we're not just picking some random case, to show that it's, especially in a jurisdiction with mass adjudication by the apex court, we have to make sure we're picking a decision that actually was representative, was viewed as representative. Tracing, determining causality is difficult. We couldn't do it in a cross-sectional way. I'm quite sure of that. I think it would have to be that kind of event study, but so yeah, interested, challenging, but I think that's the bigger project.
Well, let me say that I think comparative law is empirical in its own way. We're not coming up with theories; we're coming up with a legal institution. So in the beginning, it was like, what does he mean by empirical? And this is another conversation I had just recently. I think it's empirical in its own way. I am, very interested in what you just said, just in terms of just general background of my interest. Part of my interest in this, I do mostly corporate law, but part of my interest in this line of work is I was in the United States during the financial crisis. I went to Brazil and I started seeing the distratos line of decisions. By the way, it's not one decision. They completely have systematic effects. That's really well known. It's a decision that allowed consumers to exit contracts for mortgages. And for me, that was like, oh my, this is such a different allocation of risk. The actual effects in the United States of the crisis would have been quite different if the courts in the U.S. had adopted kind of the more heterodox approaches of Brazilian law. And that line of distratos decision, which we discussed, also relates to something that also happened in Brazil in the 1990s, in which there was the failure of a major construction company, and the courts really reinterpreted the meaning of mortgages to make sure that the consumers remain with the houses and not the banks that had finance, which would be the little. So so there are those major things in Brazil, and I think it's really, of course, it's a different crisis, different mechanisms. I'd love to know more about the particular legal issues. I think that's also interesting to see the doctrinal hooks and how they explain them. And I think this is interesting. Beyond causality, at least we see legal developments, and I think we also saw that in Brazil, the interaction between courts, and I think this is very interesting. I think it's what Daniel was saying perhaps as well, but that there's also interaction between courts and legislators. Perhaps courts overstep, and then legislatures moderate, but it's not quite orthodoxy in the end. It's just a small push. And of course, it's controversial. So I'm really interested in that case, and that helps. I think what bothers me a bit is that everything that happens in Brazil is like, Brazil is this island, right? And fine, it is. It didn't copy other systems, but courts, maybe in developing countries, those faced with those dramas, they try to push things in a slightly more fair direction, and maybe there's something we can do with that kind of housing crisis in developing countries. It's also another possible theme, and I'm very much interested in the case. Thank you.
Daniel?
Thank you, Manuel. Just a follow-up question comment. I would like to go back to two of my points in light of one of Kevin's comments about how to interpret your paper. My 2 points were the ones about, first, where to locate legal contract law heterodoxy within the landscape of the Global South countries that you choose. And the second point is about the role of the case law that you chose. Because I agree with Kevin that one of the main points of the paper is to prove wrong the dominant idea that orthodoxy is dominant in contract law, right? Therefore, if you if you present and analyze a few cases, you're going to present enough support for your general thesis. However, I would say that the paper says other important things that are as important as this first thesis. I think also that what you're saying is that the relationship between orthodoxy and heterodoxy in the Global North and the Global South is different, because what you say at the beginning when you analyze France, Italy, and Germany is, look, orthodoxy is the rule. However, you can find exceptions, right? Now, when you analyze the Global South countries, you say, well, heterodoxy is not dominant, but it can't be the exception, right? You don't say that, but it can't be the exception, because if you say so, you're saying, well, a reader would reasonably say, well, what's the difference, right? In Germany, France, and Italy, you have the rule and the exception. In Latin America or in Africa, exactly the same, right? And if you want to avoid this reading, you have to say, I would suggest a little bit more about where to locate these heterodoxy within the landscape of these countries. So if it's not dominant and is not the exception, what is, right? What is the relationship between this case law of the Supreme Courts and the case law of inferior courts? And also here, perhaps you would need to analyze not only paradigmatic cases, but more lines of jurisprudential lines, right? Lines of opinions to be able to say, no, look, this is something different than what happens in the Global North. There's a middle space that is important that we should make explicit, analyze, and it's something really distinct of the Global South with regard to contract law and inequality.
I'm not sure we concede that the three cases we discuss in from France and Italy and Germany are actually examples of heterodoxy. We think they're close, but they're close. They're more like the sort of fairness, equality, and exchange type of cases. So we actually suggest they're still within the realm of orthodoxy. But leaving that aside, I think it's fair to say that for South Africa, I'm relatively comfortable saying that this is not just, these are not isolated decisions. It's not a court, the Constitutional Court is not one that engages in mass adjudication like the courts in I'll just say pure, some of the Latin American countries, let's just say that. And so this is a substantial thread in the jurisprudence of the Constitutional Court. I'm comfortable asserting that, even if the paper doesn't demonstrate it. And I think it's fair to say that the paper falls short for failing to sort of demonstrate that, although it's a tricky thing to do. But at the same time, I was going to say this in response to your first iteration of the question, there is tension amongst the different levels of courts in South Africa. The Constitutional Court is very different from its attitude towards this, is very different from the attitude of the Court of Appeal. which is not a constitutional court. And there was a lot of commentary in the South African literature about the divergence between the two. The case with the franchisees was one where it was interpreted as a sort of reconciliation between the two. But from where I sit, they're not necessarily on the same page. And then there's some trial judges in South Africa, like Dennis Davis, who's also a leading academic and someone who's written extensively extrajudicially about transformative constitutionalism. He wrote the trial decision in that case with the franchisees, which was very progressive. He was still overturned by the Court of Appeal, and then that was affirmed by the Constitutional Court, a split decision. So there is contestation within South Africa, but these are not just isolated examples. I feel comfortable saying that to you now, and that's why we felt comfortable writing the paper that way. But I think it's a fair comment to say that that's not set out, that position isn't set out rigorously in the paper. Yeah.
Thank you, Kevin. Sergio also took part in the chat. He's recommending a case that you may want to look at, a Spanish case regarding also mortgages. Thank you for that, Sergio. And Mariana, I think that this would be a final question because we're running out of time, and this is the question. The fact that Brazil's civil code includes the social function of the contract doesn't make the whole contract law heterodox?
So really, in Brazil, heterodoxy is what we call heterodoxy is really significant object of debate and contestation. Of course, the social function is a general clause, so there are different meanings that can be attributed to it, and I think maybe 10 years ago, there was a strong sense that it would be a social justice meaning to it. I think more recently we're seeing decisions more with the law and economics bent. Social function of contract is, I don't know, reduction of transaction costs, and that is a different interpretation. But even beyond that, I was just opening the Brazilian civil code. There has been this law on academic freedom. And I think this shows like how much people think there is heterodoxy, that there was a provisional measure on economic freedom, not academic, sorry, although academic freedom is a huge problem in Brazil, maybe greater than economic freedom. Well, but so there's the provisional measure by the executive on economic freedom changing the civil code. Like, you know, and according to the Constitution, it needs to be something urgent and of great public interest for it to be through a provisional measure that's later converted into law by Parliament. And at any rate, one of the things that was done through the provisional measure and made it to the actual law change in the civil code was a new sole paragraph in the article about the social function of contract, saying that in private contractual relations, the principle of minimum intervention and the exceptional character of revision of contract terms shall prevail. I think the only way to make sense of this rule is against the backdrop of I mean, I would think that you didn't need that rule to begin with, but they found it so necessary, and you needed it by provisional measure. It's really urgent to say that courts shouldn't be rewriting contract terms. So it's hard also to prove it in terms of rhetoric of dignity and solidarity and social justice. We have a whole lot. So I think that's where it comes to the cases. We try to focus on cases that had the rhetoric, but also the very outcome seemed to be heterodox and not necessarily justifiable through the other fairness and other needs. And that's kind of a strict test to kind of show that there's heterodoxy rather than something else. But still, I think what Daniel calls exceptions doesn't bother me. I think there's nothing like those cases in the global north. So the cases that we see are different in kind, they're different in rhetoric, and I think they're different in the incidence. So even if they're both exceptional in the sense that they are not the vast majority of cases, we see them more often. And that relative difference in incidence is still interesting and worthy of study and consideration. So that's a little bit of where we stand. It doesn't need to be a majority of cases for it to be very important. And in this conversation, I think I'm beginning to think that Colombia is more like Brazil than I thought, because of the housing thing as well. And that's real. You know, it's very hard to measure, but it's real. There's something going on, and something to think about.
Thank you, Mariana. Thank you, Kevin. Well, we ran out of time. I think it was a very interesting discussion, at least for me, I guess for everyone else as well. Thank you for accepting our invitation. And I don't know if you want to say anything else, Daniel?
No, I just want to thank you, Mariana and Kevin, and the audience for this very interesting discussion.
Okay, thank you very much,
Thank you.
and see you next time. Take care.
Bye-bye. Thank you very much.